On the 14th of September, the Trademarks Amendment Iconic Symbols of National Identity Bill was introduced to Parliament by Federal Member Bob Katter, prompted by indignation at recent applications by various trademark applicants for trademarks consisting of the words Waltzing Matilda. The bill proposes a new ground for rejecting an application if the trademark consists of a sign which is of national significance or iconic value to the people of Australia. In his press release, Mr. Katter said, "By definition, a symbolic emblem, whether it is Ned Kelly, the man from Snowy River, Boomerang, or the Rising Sun badge, should not be able to be turned into a property right." The explanatory memorandum provides no guidance as to the types of signs that would be captured by this amendment. Reports suggest that Mr. Katter proposes the introduction of a committee which would make this determination. Presumably, this committee would be similar to the Maori Trademarks Advisory Committee, which considers whether trademarks referred to it by the New Zealand Commissioner of Trademarks are likely to be considered offensive to Maori. In my view, Mr. Katter's proposal raises a number of areas of concern. Obviously, there needs to be greater certainty around what constitutes a sign of national significance or iconic value. The inclusion of Ned Kelly in Mr. Katter's examples of symbolic emblems raises an interesting issue surrounding the ability of an individual of arguably national significance or iconic value to register and exploit their own name. For example, would marks such as Weary Dunlop be prevented from securing registered rights? And given the significance that Australians place on their sporting identities, should people such as Greg Norman, Leighton Hewitt and Ricky Ponting all be denied the opportunity to generate income from their self-branded goods and services? In addition to the further delay that referral to the committee would add to the examination process, another issue is whether or how the decision of the committee could be challenged. Is this an issue that could be argued before the trademarks examiner? Or would there be a separate review or appeal process before the committee? Furthermore, given that the proposed ground for rejection applies only to marks consisting of a sign of national significance or iconic value, I wonder whether the objective of the bill will be achieved if trademarks which merely include a sign of national significance or iconic value will not be subject to the ground for rejection. So I think it's fair to say that in its present form, the proposal raises a number of areas of concern for potential trademark applicants. Perhaps more troubling is the proposal relating to revocation of registration. Rather than providing a power to revoke, the proposed amendment imposes an obligation on the Registrar of Trademarks to revoke the registration of marks consisting of a sign of national significance or iconic value. This obligation to revoke will apply not only to marks registered after the commencement of the amendments, but also to any mark registered before the amendments. So what would that mean in practical terms? Firstly, the Registrar would be required to conduct a review of the approximately 610,000 registered Australian marks and then provide an opportunity to be heard to the owners of all of those marks for which it proposes to revoke registration. Now, clearly that's a monumental task and it's likely to exhaust IP Australia's already stretched hearings resources, possibly for years. Secondly, what would this obligation to revoke registration mean to trademark owners? Although one can only assume that Mr. Katter intends that the amendments apply only to symbolic emblems, would the amendments extend to brands which fall within the definition of signs in Section 6 of the Trademarks Act? Would anyone argue that brands such as Vegemite or Qantas, for example, are not signs of national significance or iconic value to the people of Australia? Would this mean that the Registrar would be obliged to revoke the registration of these and other similarly iconic Australian brands? And what would the loss of these exclusive rights mean to the trademark owners? Not to mention the risk to consumers if these marks were free for use by all other traders. It's clear that considerably more detail is required before we can fully assess the likely efficacy of Mr. Katter's proposal. It is worth noting, however, that Section 39 of the Trademarks Act already provides a ground for rejecting an application if the trademark consists of a prohibited sign. Prohibited signs are detailed in the trademarks regulations and currently include the flag and emblems of the Commonwealth, state and territories, and other phrases such as Olympic champion and returned soldier. In those circumstances, I wonder whether Mr Katter's objective would be better served by proposing specific amendments to the list of prohibited marks. This would certainly provide greater clarity and transparency for trademark owners, applicants and consumers alike. We will continue to monitor the progress of the bill and keep you informed of any developments.